The question is that the bill be now read a second time. I call the member for Newtown.
Thank you, Speaker. I rise to speak on behalf of the Greens on the Crimes Legislation Amendment Sexual Consent Reforms Bill 2021. This bill will amend the Crimes Act 1900 in relation to consent to certain sexual activities that, in the absence of consent, are sexual offences, and to amend the Criminal Procedure Act 1986 in relation to directions to juries and for other purposes. The Greens enthusiastically support this bill that will see a model of affirmative consent inserted into law in New South Wales. This bill recognises that 1, every person has the right to choose whether to participate in a sexual activity. 2, consent to sexual activity must not be presumed. And 3, consensual sexual activity involves ongoing and mutual communication, decision-making, and free and voluntary agreement between the persons participating in the sexual activity. The bill also updates the language of provisions of the Crimes Act 1900 relating to sexual offences and allows, in some circumstances, requires judges to make directions to juries about consent in trials relating to certain sexual offences under the Crimes Act 1900. Let us make no mistake. This is a significant moment. This is a very significant reform. For so many, this reform is personal. Dealing with this subject matter is very traumatic because the acts of sexual assault and sexual violence and rape that were subjected onto and put onto these people were clearly very traumatic. This reform was a long time coming, and it is also a significant step in addressing and moving towards eliminating the excessive levels of sexual assault and sexual violence in our society so that we are all free to participate freely in all aspects of society without fear. While it is important to acknowledge the Attorney-General in bringing this bill to the Chamber and the multi-partisan support that this bill has in this place, it is critical that we acknowledge that credit for this reform sits with some incredibly strong survivor advocates, feminists, experts and activists who have been through so much and who have never given up. First and foremost, thank you and acknowledgement to Saxon Mullins, who led the way with this reform with such strength and care and compassion, bringing other young activist survivors, experts and women with her. To Saxon and to all of the survivors and survivor advocates who have found themselves subjects of bad laws that fail to realise the realities of how sexual assault, rape and sexual violence and non-consensual sexual acts occur, I send you my solidarity and respect. And let me say that today, in passing this reform, we are doing all that we can to ensure that those in the future are not subjected to the same injustices that you have been subjected to. So many have campaigned so hard for the introduction of affirmative consent laws in this state, and credit must go to Dr. Rachel Bergen of the Rape and Sexual Assault Research and Advocacy for her tireless campaigning, along with Saxon Mullins on this issue. Dr. Bergen has played a significant role in keeping consent reform on the agenda and providing clarity around exactly what needs to change. A shout out to everybody at Women's Safety New South Wales, to Hayley Foster and Laura Henschke at Rape and Domestic Violence Services Australia, to Liz Snell at the Women's Legal Services New South Wales, Delilah Donovan, Renata Field and Bridget Mottram from DV New South Wales, Jules Kim from the Scarlet Alliance and Teddy Cook, Felix Delhomme and Eloise Layard from the ACON for their expert analysis and research and advocacy and reform. To all of the incredible activists who put themselves at front and centre of the marches for consent reform in this state and refused to back down, to Dani Villafana, Chloe Corbell, Erin Leary and the youth survivors against sexual violence, to Jamie Evans from the team at Women's March Sydney, Fair Agenda, End Rape on Campus Australia, Chanel Contos, Dr. Amanda Cohen, Danya Marnie and Dr. Karen Williams, to the 2,000 people who signed our consent reform petition back in February this year, calling on the Attorney-General to introduce this enthusiastic consent bill, and to the 6,000 survivors who gave their personal testimonies to teach us consent, and the tens of thousands of women who marched for justice outside of this chamber in March this year to demand this reform. This reform is yours. I want to acknowledge all of the member organisations as well of the New South Wales Women's Alliance who worked so hard for this reform, some who I've already mentioned, and also an incredible list of organisations, of women's groups and advocacy organisations that have pushed for this. Because of you, we are here now and about to pass a bill that implements an affirmative model of consent in New South Wales. We are about to pass a bill in New South Wales that acknowledges the reality of how sexual assaults occur, including acknowledging the different ways that victim survivors may respond. A bill that gives clarity to our police, to our courts, to our juries in assessing all of the circumstances around which an alleged offence was committed. A bill that places the onus of the perpetrator onus on the perpetrator to prove that they took steps to ascertain consent. Gone are the days when consent could be inferred or implied in New South Wales. This bill requires consent is clearly and positively communicated continuously throughout the sexual act. This is powerful stuff to smash the patriarchy. We are particularly pleased that this bill goes further and beyond the recommendations of the New South Wales Law Reform Commission to require a person who claims to have had a reasonable belief in consent to demonstrate what they did or said to ensure that they had that consent. This is a true testament to the strength of organisations and the activists mentioned above, because we mobilised, we chanted, we made submissions, we met with people we persuaded, and we did it. We push this reform to where it needs to be. The Greens absolutely support this bill. We enthusiastically support this bill, and we want to make sure that it is the strongest and best that it can be when it comes to delivering on the objectives, and that there aren't any unintended consequences, hidden rape myths, or outdated traces left lingering in this legislation. As such, we will be moving a number of amendments that have been supported by key organisations and experts that have been advocating for this reform. And we will also be foreshadowing that some of those will be moved here in the LA and others will be moved in the Legislative Council. In addition to this, there are some elements of the bill that we are seeking genuine clarification and additional information from the Attorney General on, so that we may consider those responses and see whether further amendments may need to be moved in the Legislative Council depending on how those responses are provided. It is our strong hope that these amendments can be considered and that the bill is passed before the end of the year. We know that the time for submissions and inquiries is over, and after we all started the year marching with women demanding for justice and demanding consent reforms, so it would be so powerful to see the year end with these reforms and a model of affirmative consent passed into the Crimes Act and into law into New South Wales. I would like to now address and turn in detail towards the bill, and I'd like to, before doing so, acknowledge both the government and the opposition and the Parliament's support in agreeing to allow me additional time, usually just afforded to the Minister and Shadow Minister, to be able to do this reform justice. While we support the existing amendments in the bill, it is our view that the objectives at 61.8F need to be expanded, and we will be moving an amendment to this effect to better reflect the reality of sexual offences and sexual offenders in our current society. As it stands, these objectives fall short of the standards and recommendations of the Australian Law Reform Commission report on the issue, and the expansion of the objectives would be a recognition of the reality we are in when it comes to sexual offences relating to consent. This bill, at its core, is about establishing an affirmative model of consent in New South Wales, and we want to ensure that it absolutely delivers on this. It is for this reason that the Greens will be moving 2 amendments to strengthen the model of affirmative consent in the bill in the Legislative Assembly. Rasara, in a submission on this consent reform, made it clear that affirmative or communicative consent is an, and I quote, ongoing willingness to engage in a sexual act, either verbally or through their actions. It must be positively expressed in some way. It cannot be implied from lack of resistance. It cannot be inferred from the victim's actual or perceived behaviour. It must be present at the time of the sexual act occurring and continue while the act occurs. Following on from this, the first amendment that the Greens will be moving in relation to strengthening the definition of consent generally at 61HI1 would be reinforcing a communicative nature of consent, so that at 1 it would read, A person consents to a sexual activity if, at the time of the sexual activity, the person freely and voluntarily agrees to the sexual activity and communicates this by words or actions. The addition of the "and communicates this by words or actions" is crucial and is exactly what the affirmative consent model is all about. In relation to the reference at 61HI2, there is a genuine question to raise as to whether or not the inclusion of the words into "by words or conduct" negates the concept of affirmative consent. There is a real question that needs to be addressed and answered to make it very clear that conduct in this section includes freezing, submission, a lack of active participation. We do not want to see a situation where the very nature of affirmative consent, which requires that one does not need to withdraw consent, but rather consent must continue to be actively given, is undermined by the narrow definition of conduct that does not recognise the reality of many victims when they engage in what has been described as a freeze response. And I would ask the Attorney-General to address this in his reply. The second amendment in relation to strengthening the affirmative consent provisions in this bill seeks to rectify an issue with the time frame associated with consent at 61HK2, and I note that the Shadow Minister for Women addressed this when she was speaking just earlier. It is critical, and it's the Greens' view that we need an amendment in relation to this, that consent is present at the time of when the sexual act occurs and continues while the act occurs. It is not acceptable to set out in this bill that it happens within a reasonable time frame. It must be, as our amendment seeks to do, be immediately before, and I'll speak further to the reasons around that and the murky territory that putting something in there around reasonable time puts us in relation to this bill when I speak to that amendment in more detail. Also, in relation to 61HK2, it is my understanding that an earlier draft of the bill contained the word overt, so that it required a test of whether the accused person said or did anything overt to find out whether the other person consents to the sexual activity. It appears in the final version of the bill that we have before us that this obviously stronger position has been changed and the word overt has been removed from the earlier draft. I would appreciate the Attorney-General offering some clarification or detail as to why we have seen the removal of this overt within that clause. On the issue of mental health impairment in section 61HK3, the Greens wish to indicate our serious concern and put on the record the concern of many advocates, experts and organisations that we have consulted with on this reform in relation to mental health impairment. I will go into more detail when I speak to this amendment, but in short, the definition of a mental health impairment as set out in the Crimes Act is far too broad, and this section significantly undermines the affirmative consent objectives of the bill by making it far too easy for an offender to escape any requirement to have taken any steps to ascertain consent in order for belief in consent to be reasonable. The issue of mental health impairment includes and encaptures people that suffer from an anxiety disorder or suffer from depression, and clearly these would be inappropriate things for someone to rely on when it comes to having met the test to have been taken reasonable steps to ascertain that consent has been given. On another issue, the concept of proper medical or hygienic purposes is referred to throughout the bill, and based on our consultation with ACON, we will be seeking to make an addition to the Schedule 1.1 to insert at 61H3 a reference to ensure anything carried out by a health professional is not for proper medical or hygienic purposes unless it is carried out in accordance with relevant professional standards and clinical guidelines for care. We have also identified a number of inconsistencies in the way that genitalia are referred to within the bill, and will be moving minor amendments to provide for more inclusive and consistent language at 61HAC and at 80A. We will be moving 2 amendments in relation to this in order to bring consistency to the bill when it comes to the use of gendered language around genitalia. We note that stealthing, or specifically non-consensual condom removal, is referred to in an example in the bill under 61HI5 that sets out that a person who consents to a particular sexual activity is not, by reason only of that fact, to be taken to consent to any other sexual activity, with the example stating that a person who consents to a sexual activity using a condom is not, by reason only of that fact, to be taken to consent to a sexual activity without using a condom. We seek additional information from the Attorney General around why the decision was made to put this as an example rather than explicitly including non-consensual condom removal in this reform. We also note that at 61HJ, 1, E2 and F2 both relate to and refer to a person participating in a sexual activity because of force, fear or fear of serious harm. In discussions with some stakeholders, they have suggested the need to explicitly refer to coercion in this section, and also to remove reference to serious harm and instead replace it with harm as an alternative. We note that Rape and Domestic Violence Services Australia have expressed to us a concern that the bill does not adequately address sexual offending in the context of domestic or family violence, and in particular in circumstances of coercive control. As such, any additional information and reassurance the Attorney General can give in relation to this decision to not explicitly refer to this would be welcome, so that we can consider whether or not we seek to move amendments in the Legislative Council. I would like to turn now to an issue around fraudulent inducement, with a request for the Attorney General in his response to reassure the community in relation to this. The specific clarification and need for reassurance around this has come from ACON and relates to HIV status. We know that it is no longer a requirement to disclose HIV status under the Health Act, provided that precautions are being taken, which is a very welcome situation and a very good and positive sign of the success of powerful public health work and medical advances over decades. It is absolutely correct that HIV non-disclosure should not be a matter of consent, but rather an issue of public health around the reasonableness of the precautions taken. I note that in his second reading speech, the Minister noted that fraudulent inducement in the context of these reforms requires something more than silence or non-disclosure on the part of the accused. It requires a positive act or spoken words amounting to a falsity which the accused knows to be false. This would imply that non-disclosure of HIV status would not meet the bar of fraudulent inducement, but I ask that the Minister reassure the community and explicitly state this and confirm that that is his understanding in his response. It is our understanding, however, that fraudulent inducement would apply in a situation where a person lied about their precautions or management of the HIV, for example, saying that they were on PrEP or UVL in order to have sex with someone when they actually weren't. As I mentioned, the Greens will be moving some amendments in the Legislative Council, and I foreshadow that these will relate to removing potentially undermining qualifying language, specifically the word necessarily, from 292C and 292D, adding a specific jury direction around family violence in 292F, and inserting a reference to community standards at 61HK to account for offenders who may hold personal opinions, values or attitudes that do not meet these standards, and potentially strengthening protections for sex workers. The final amendment we will be moving in this chamber relates to the review of the reviewable provisions in the bill. The changes that we are aiming to make with this bill are significant, and it is our strong position that the first review of this bill should take place in 3 years, not 5 years, and that there should be a regular 5-yearly statutory review after that. We also note that the Attorney General's comment that this reform can only be successful if delivered alongside adequate education is something that so many highlighted in their submissions. As such, we will be seeking to add in a requirement for the Minister to table a report detailing what education and training has been delivered to police, judges, prosecutors, the departments, agencies and the general public before the review of the bill comes into effect, so that the community, the stakeholders, the people that are going to be engaging in the review are aware of what training and what actions have been taken. All of these amendments that have been drafted have been done so in consultation with experts, with RASARA, Rape and Domestic Violence Services Australia, Women's Legal, DV New South Wales and ACON, and I urge the government and the opposition and the crossbench to support them. Speaker, if I may have the indulgence of 30 more seconds in addition to my 30, I'll conclude my remarks. Sorry, do you need to?
I will have to put the question to the House.
Speaker.
While the resolution that the House to provide for up to 20 minutes for the member for Newtown, I will put the question to the House that the member's time now be extended. All of that opinion say aye. To the contrary, no. The ayes have it. The ayes have it.
Thank you,
You have the
Speaker.
call.
This reform and the much needed education around it could be the beginning of the end of rape myths. It could end the questions about what she was wearing, what she drank, why she didn't fight or run or scream. Consent law reform was number 1 on the New South Wales Women's Alliance 9-point plan to address sexual violence in this state, and now we can tick it off. I'll take a moment to put the government on notice that we will be ready in 2022 to tick off numbers 2 through 9. Before the Me Too movement was a global hashtag, a brave survivor advocate named Saxon Mullins made the decision to speak publicly. In taking that step and in doing all that she has done since, she and many like her got us to the point we are at today. In March, tens of thousands took to the street to stand with survivors in the March for Justice, where we said enough is enough to sexual violence and demanded consent reform and consent education. Now today, we see the power of movements to change laws, to reshape society and to smash the patriarchy. This is how we got here, and this is how we win. Nothing will ever take away the pain, the trauma, the impact of rape, sexual assault and sexual violence on those who have experienced it. The best we can do is to respect the calls of those victim survivors, those victim advocates, the calls that they are making for reform. And they have been enthusiastically saying, we need this reform. Today, we move one step closer to doing this.
Thank the member for Newtown.